Okay, well, good morning or good afternoon for the folks who have joined. We're really pleased that you are able to join us today for this Constangy Cyber Academy session. Looking forward to spending the next hour having a conversation with all the attendees. And again, if you've got questions, feel free to put those into the chat as we go along. And we'll be talking about data breach regulatory reporting requirements, investigations, and sort of the life cycle of a regulatory investigation on the back end of a data security incident. We can move to the next slide. Very pleased again to be here with you today along with my colleague Kim. I'll start off just by introducing myself. For those of you I do not know, my name is Donna Maddox. I'm a partner here with the Constangy Cyber team. I have been working with this team as part of the incident response group for close to 5 years in different incarnations. I started in September of 2020. Prior to joining this team, I was a federal prosecutor for 8 years and was also with the Oregon Attorney General's office as a criminal prosecutor for 10 years prior to that. And it's really my experience as a criminal prosecutor in what I would call regulatory adjacent areas. A great deal of the work I did in the prosecution landscape were in areas including tax enforcement, Medicaid fraud, healthcare, social services fraud. So a number of the cases that I worked over that almost 20 years were not only regulatory adjacent, but sort of a regulatory action had preceded it. So it's my experience there, and again, long experience with the Oregon Attorney General's office that really helps me work with clients through the regulatory process. And I do oftentimes work with folks on our team in the responses to and sort of strategies around responding to regulatory investigations. Kim, over to you.
Thank you, Donna. Good morning or good afternoon, and thank you again for being here. My name is Kim Detweiler, and I've been with the Constangy team for about a year and a half. I've been in the incident response space for approximately 2 years. Before joining the team, I was in federal law enforcement for over 20 years. I was a Secret Service agent assigned to both the Philadelphia and Washington field offices, and then worked at headquarters for 4 years before I retired in 2022. So during my time in the Secret Service, I investigated numerous cyber crimes, including wired and bank fraud cases. And as much as I love my time in government service, I was ready for the transition to the private sector, and I'm happy to be here.
All right, thanks, Kim. All right, we're going to jump into the next slide and kind of just give you an overview of the goals of our sessions today. So what is it we're going to be covering in this hour-long session that will also provide all of the attendees with CLE credits or CE credits? So again, just wanted to make sure that there's a heads up that there will be polling that is happening throughout the presentation that we'll need to make sure that we're doing to comply with the requirements for those CLE credits. So we'll give you a heads up when those are coming. But again, just to remind all the attendees that we will have those polls throughout. So our sessions here, we're going to review the data breach regulatory requirements and trends. It's going to be a high-level overview. I think of it more like Cliff Notes, because we could spend days talking about the regulatory landscape here, but we wanted to really just give an overview of some of the primary regulatory requirements that we're seeing and interfacing with on a regular basis. We also want to discuss the process for regulatory investigations. What do they look like? How will they play out, both for clients, carriers, and counsel? And also talk a little bit about some of the strategies that we employ when we're dealing with enforcement actions and decisions about whether or not to settle an enforcement action with a regulatory authority. And again, just a high-level overview of best practices for how to navigate this ever-changing, ever-developing, and sometimes very complex landscape that we're seeing. So with that, we will head into our agenda. And Kim, I'm going to turn it over to you.
Thank you, Donna. We are going to start first with an overview of notification obligations. So after an organization sustains a data breach, there are many sources that can trigger regulatory notification obligations. And here we have a list of some of those sources. There are state data breach notification statutes. These are the laws enacted in all 50 states that require entities to notify individuals when certain personal information has either been accessed or acquired without authorization. We will cover these in more detail later on in the presentation. We also have sector-specific laws, which add yet another layer of complexity to breach notification and compliance. So one example of a sector-specific law that pertains to education is the Family Education Rights and Privacy Act, which is FERPA. FERPA's provisions govern the privacy of education records and apply to institutions that receive federal funding from the U.S. Department of Education. So under FERPA, personal information includes information maintained in education records, which can be direct identifiers such as student's name or identification number, or indirect identifiers, which is other information that can be used to distinguish or trace an individual's identity, either directly or indirectly when it's linked with other information. So FERPA doesn't require schools to notify parents or students of an unauthorized disclosure of PI. However, it does require schools to record the disclosure in the student's record so that when a parent or student has an inspection of the student's education record, they'll be aware of the disclosure. We also have the Health Insurance Portability and Accountability Act, also known as HIPAA. This imposes legal obligations on covered entities and business associates that use and transmit protected health information. There are so many definitions and requirements that we could spend an entire day. I think some would even say an entire week on the nuances of HIPAA, but we just wanted to mention it here. There are sector-specific laws for clients who engage in financial services, such as the Graham-Leach-Bliley Act, also the GLBA, which governs businesses engaged in financial activities, including lending, exchanging, transferring, investing, and safeguarding securities. And we as attorneys face unique obligations under professional responsibility regulations, requiring notification to clients when certain breaches occur that reach a material threshold. And if that's not enough, there are also industry standards. So in addition to the state data breach notification statutes and any federal regulations, some organizations are also required to maintain security controls to protect consumer information. And if these standards are not met, consumers who have been impacted may allege unfair and deceptive trade practices. This can lead to massive class actions or regulators to impose penalties for inadequate controls. So we can talk about some of these standards in more detail. But here we've listed the Payment Card Industry Data Security Standard, or the PCI DSS. Organizations that process payment card data must comply with the PCI DSS, which includes requirements for protecting cardholder information and responding to these breaches. There are also financial industry regulatory authority standards. This is more commonly known as FINRA. FINRA provides cybersecurity guidance that complements but doesn't replace federal and state laws. So through our expertise with hundreds of data security matters, we have found that compliance with not only the state and federal laws, but also these industry standards can help mitigate risk and demonstrate due diligence in the event of a breach. However, the complexity here is the overlapping requirements that must be managed to avoid gaps. So on the next two slides, we have additional federal laws and regulations. We've briefly mentioned some of these already, and others we will be discussing later in more detail. These laws and regulations also provide us with guidance into potential notification obligations. So for example, the Defense Federal Acquisition Regulation Supplement, which is also known as DFARS, these are requirements that are incorporated into federal contracts and require Department of Defense contractors and subcontractors to provide adequate security on all covered contractor information systems and to rapidly report a cyber incident after discovery to the DoD by way of the Defense Industrial Base, which is the DivNet portal, within 72 hours. So a covered contractor information system under DFARS is one owned and or used by the contractor and contains and processes covered defense information, which is also known as CDI, or controlled unclassified information, which is known as CUI. So DFARS defines a cyber incident as actions taken through the use of computer networks that result in a compromise or an actual or potentially adverse effect on an information system and or the information contained within the system. So if we have a client who has government contracts, it's really important to ask if they are either a contractor or a subcontractor who owns or uses a covered contractor information system during the scoping call, since this is such a tight reporting period. We also have the U.S. Department of Treasury's Office of Foreign Asset Controls, which is OFAC. We use OFAC as a screening procedure that is likely familiar to most of you. We process the wallet addresses through OFAC when we are moving towards payment to a threat actor. This compliance check ensures that we are not providing payment to a terrorist organization or an organization that is a threat to national security. So state and federal laws and regulations. So as we discussed, the state data breach notification statutes trigger whether regulatory reporting is required in the first place. So the application of state data breach notification statutes depends on the residential location of affected consumers or individuals. So for example, the California statute requires notification to a consumer when there has been unauthorized acquisition of computerized data that compromises the security, confidentiality, and integrity of PI. Whereas Florida requires consumer notice when there has been unauthorized access of data in electronic form containing PI. So both of these states regulate computerized or electronic data, but what constitutes a breach is different. So once we work with our clients to produce a final list of potentially affected persons, a notification vendor then processes this list through the National Change of Address database. And this provides us with the final population. From here, we'll receive a table of state counts, which is the number of affected individuals who reside in each state. We'll use these state counts to determine whether regulatory notification is required in that state. So at this time, we also examine the regulatory obligations of the state with regard to the consumer notification letters. So for example, some states require that affected individuals are offered 12 or 18 months of credit monitoring, while others, such as Massachusetts and Connecticut, require 24 months. So timely notification is not only a legal obligation, but also a critical component of avoiding regulatory inquiries or fines. There's also a difference between consumer notification timing and regulatory reporting timing. Many states require that consumer notice be made in the most expedient time possible. So for instance, Florida notification timeline is as expeditiously as practicable and without unreasonable delay, but no later than 30 days after determination of the breach. Whereas North Dakota requires consumer notification in the most expedient time possible and without unreasonable delay. But notice here, there's no number of days that is required. So with regard to reporting to regulators, as previously discussed, regulators could be the state attorney general or the state police department or another department for that state. Massachusetts requires notice to both the state attorney general and the Office of Consumer Affairs and Business Regulation. But in New York, the attorney general, the secretary of state, and the superintendent of the state police must be notified. There are also 3 methods of reporting. U.S. mail, this is Virginia that requires that. We can also report by email, that's Maryland, Montana, Puerto Rico, and Indiana. And the trend that most states are moving towards is website portal. So states that require notice to be provided by the portal each have different forms of what is required. Some require detailed information, such as what security measures clients had in place prior to the incident and what clients have implemented in an effort post-incident to avoid a similar incident happening in the future, while others just require the name of the entity and, an overall general description of the incident. The timing of these notices must align with the overall response strategy in order to ensure compliance. So the challenge arises when there's a delay in notification to one group. So, for example, if regulators are notified, but the consumer notifications are delayed, organizations could face legal risks. So ensuring alignment between these timelines is the key to staying compliant.
Hey,
Here we
Ken,
have, yes.
did we skip slide 11? There we go. Oh, no, we're good. Okay, just checking.
Okay, thanks. So here we have a list of some of the states that publish the details of the regulatory filings on their websites, and others publish the regulatory notice letter that we attach to the filing. Some of these states post the total number of those affected by the incident. Others post the number of residents that were affected in that state only. And some, if there's a cover letter submitted explaining the incident, that includes the details of the incident with date of discovery, dates that consumers were notified, and the PI elements involved. Some states like Maine publish this letter. The issue with states publishing any of this information, and especially the regulatory notice letter, is that plaintiffs' class action counsel track these publications to initiate class action lawsuits. And lately, we have really seen an uptick in these lawsuits, even for populations under 1,000 people. So here we have some examples of state sector specific and industry laws. We have the New York Education Law, Section 2D, that restricts education agencies from selling, using, or disclosing PI for marketing or commercial purposes. We have the California Health and Safety Code, Section 1280.15, which requires a clinic, health facility, home health agency, or hospice to report any unlawful access to or disclosure of a patient's medical information to the department no later than 15 days after it occurs. And the National Association of Insurance Commissioners model law implementations require insurers to develop and maintain an ISP, an information security program, based on its risk assessment with a designated employee in charge of the ISP. So as an example, we also have the New York Department of Financial Services, the NYDFS. Rules, the NYDFS states that covered entities must notify them of a cybersecurity incident as promptly as possible, but in no event later than 72 hours after determining a cybersecurity incident has occurred. NYDFS defines covered entities as any person operating under or required to operate under license, registration, charter, certificate, permit, accreditation, or similar authorization, regardless of whether the covered entity is also regulated by other government entities. A cybersecurity incident is a cybersecurity event that impacts the covered entity and requires the covered entity to notify any government body, self-regulatory or other supervisory body, or results in the deployment of ransomware within a material part of the covered entity's information system. So since this notification is required no later than 72 hours, it is important that we discuss NYDFS regulations with our clients who perform financial services, whether they are licensed or registered to do business in New York, or insurance companies who are doing business in New York during the scoping call. Here we have a list of some of the reporting requirements for federal laws. We have SORCIA, report to CISA 72 hours after a reasonable belief that an incident has occurred. We have DFARS, which we mentioned. That reporting is within 72 hours of discovery of the incident. FERPA, in some instances, educational institutions must notify FSA. And we also have the FDIC, the OCC, and the Federal Reserve Board. These rules normally involve our banking clients. it is important to determine which body governs each client so we can notify these entities in a timely fashion. And so, for example, banks are regulated by the FDIC, while credit unions are regulated by NCUA. So FTC safeguards rule, we will go in more detail on the next slide. The SEC for public companies, for investment advisors, the requirement is 4 business days after the company determines the breach was material. And the SEC rules for registered investment advisors, this is as soon as practicable, but no later than 30 days. So here we have the FTC safeguards rule. The FTC first published its implementing regulations, which is the safeguards rule, in May of 2002. But in October of 2023, the FTC updated this rule and put it into effect on May 13th of 2024. So this rule applies to any institution that is engaged in an activity that is financial in nature or incidental to financial activities. This applies to activities that include underwriting, insuring against various loss, providing investment services, and offering loans. So this may apply to organizations and businesses that you don't typically consider financial institutions. So as an example, we recently had to report on behalf of a car dealer since they engaged in an activity that is financial in nature because they offered loans. So what are the requirements for notifying the FTC? The incident must have affected at least 500 consumers, and notice must be provided no later than 30 days after discovery of the incident. Notice must be made on the website, and there is a very brief form to fill out to include the name of the entity, the number of affected customers, and the dates, and a brief description of the incident. And even though this is a new regulation, Donna and I have already gone through this experience together. We've already received not necessarily an official inquiry, but a follow-up from the FTC in order to confirm or provide additional details surrounding the incident. But thankfully, there has not been an official inquiry. Donna, I don't know if you wanted to expand on that.
No, I think you covered that well, Kim. I will just say that, it's interesting for some of these newer requirements. It's clear when we speak to the investigators who are involved that they're still figuring it out too, in terms of how follow-up is going to look and the types of matters that they're going to have a particular interest in. So I think that's my only comment on that.
Thanks, Donna. Okay, so now we have our first polling question.
Kim, why don't you read that off? Because the way it pops up on my screen, it sort of blocks it.
Okay. What is most challenging about regulatory laws, industry standards? The ever-changing landscape, they're difficult to comply, clients ignore the rules, or they are not clearly written.
Everybody a minute to fill that out, and we'll let our polling people know when it's closed out. And this one is a give the best answer. We talked about the fact that perhaps you could look at a few of these answers as possible, but one is definitely more right than the others, I would say.
Okay. Okay, so now I'm going to hand it over to Donna to talk about regulatory trends.
Great. Yeah, and I will note that the majority of you, 85% of you, got the right answer on that one. It was, in fact, the ever-changing landscape. It changes quickly, very, very quickly for us, constantly. It would be great if the legislatures at the federal and state level all decided to do these all at one time. They do not. So we're constantly checking to see if key components of all of these statutory requirements that we really just breezed through and highlighted have changed or altered. And we have been, just this week, I've been looking at changes at some of the, state definitions of PI, federal definitions of timing. Before we move into the trends part, if anyone has any questions about any of these statutes and how they, might apply to our clients, please feel free to jump into the chat and ask some questions. We are willing to take questions throughout the presentation, and certainly can do that. I did also just want to highlight, because I think it's super important for counsel, clients, and carriers to really have on their radar the ones that Kim highlighted that have what I'm going to call sort of the hair trigger timelines, right? So if we're talking about an entity that has potentially a DFARS obligation or an NYDFS obligation in particular, or obviously for SEC public entities that need to do reporting, there's a very short window of time that they have to analyze, is this in fact a cybersecurity incident that would trigger a legal obligation? Because not every incident triggers the obligation under the particular statute that is listed. And so really digging into those, working with our clients, and really, working sometimes in conjunction with any of their, outside or inside counsel that have done some of this preliminary regulatory work can be critically important. Oftentimes clients come to us in an incident and they have not done this regulatory work. And so we're jumping into action in the first instance to make determinations. And I will note, before we talk about these, Kim and I talked about this yesterday, there's a whole landscape of other areas that we haven't even mentioned. And recently, in one of my matters, the affected entity was in telecoms area. And there is a whole universe of state-by-state utility-related regulatory reporting obligations when it comes to impact to utilities, with completely different definitions of what constitutes personal information in terms of what is actually impacted. And my particular client was in a state where there was a utility-related reporting obligation to a regulator, but we dug in and found out by looking at those definitions that it turned out telecoms was exempted, was not listed as a utility in those. So really getting that early sort of reporting, because what we don't want to do is report to a regulator early, or report to a regulator in a circumstance where the law essentially does not require us to do so. Because as you're going to see in a minute, once we report to the regulator, we are now on the radar in terms of future enforcement actions. So did want to flag that. Don't see any questions. So let's move on to the next slide, Kim. Okay, in terms of trends, what are we seeing from the states? And I would say from a state side, what we are seeing from the states is more, just more. More regulatory oversight, more outreach, more activity in terms of what we're seeing on the back end. And as Kim said, some of this is making sure we're just tracking and understanding what is the format that they are going to require that report to happen in at that time. And then once we've done the consumer notification, and now we've done the regulatory notice because we've sent a certain amount of letters into their state that will trigger that obligation. The next thing is, which of these states are going to start following up with us? Which of these states can we expect to hear from? Certain state attorney general's offices have historically been very aggressive in this area, and Indiana is going to be top among them. Anyone who's worked in this space for any amount of time understands that when you send a regulatory filing to the Indiana AG's office, and it used to be, even if there was just one or two people involved, it used to be in every single case, they sent out a written regulatory inquiry. They have slowed down on that. They really seem to be focusing more on larger ones of ransomware now, just as a function of, I believe from conversations with them, just they've got too many, right? So like everybody else, they need to triage. But we are hearing from Indiana frequently. The other states that are listed there, Connecticut, New York, Oregon, Florida, North Carolina, we see them frequently. Utah is one that is really also stepping up in outreach now in terms of actions. And we, our crystal ball, to the extent we have one, tells us we're probably going to see more of these. And some of that has to do with what's happening on the federal landscape. Kim, any other states that you would add to that list in terms of more aggressive outreach?
Montana, actually, which is a new one for me, for sure.
Yeah. Yeah. So again, ever changing, ever developing. We're not seeing states do this less. We are seeing states do this more. So next slide. On the federal side, as you all may have noticed, there's been some changes in the way federal agencies are administered and staffed in the last 6 to 9 months. And what we were seeing in terms of our reports to federal agencies is that there's a lot of disruption in terms of the federal enforcement arms. And we really are just waiting at this point to kind of see what's going to happen in terms of trends related to enforcement actions. We are, as Kim mentioned earlier, we are seeing pretty regular outreach from the FTC if we file under the safeguards rule, if only just to clarify and ask background questions about what we're asking about. If we are reporting to the Department of Education under some of those federal requirements, we are regularly also receiving outreach from there. I think it goes without saying that in the DFARS context, we are going to get immediate follow-up or very quick follow-up, and they're going to stay with us until we can give them essentially the answers to the questions they need. And we'll talk about that in a little bit. In the HIPAA landscape, under the HHS, Health and Human Services Office of Civil Rights Investigations. That as a rule, they will conduct a full investigation in all matters that impact 500 or more individuals. That's been their standard approach. We are still seeing that. We haven't seen a drawback in that yet, but we know that their staffing has been reduced dramatically in the last 6 months. And so it really does, stand to reason that we may see some consolidation or slowdowns in the issuance of some of the investigative demands from HHS OCR. And again, it sort of remains to be seen what kind of a position they're going to take in terms of their regulatory actions. Historically, HHS OCR, and we'll talk about this a little bit more later, will do a very full investigation, lots of demands in terms of written productions, but would in most cases, close out a case without a fine or an enforcement action, which is not to say that they don't do them. They certainly do, and they have a history of bringing enforcement actions. But luckily, in most cases, clients of our size and scope have been able to close these out with a warning letter or some education about compliance. And so that we're hoping that that continues, but again, we will see. Kim? Okay, so we've been talking about, what are the regulatory reporting requirements in the event of a cybersecurity incident? And then what happens when we have a consumer notification that requires us to report to a state and or we've reported to a federal agency? And this is really going to be on the state side in terms of enforcement, but it applies equally across the state and federal landscape. Once you have essentially put yourself on the radar of a state regulator, the questions they ask you about compliance typically are not going to be limited to what happened in the incident and how did you mitigate the incident and tell us about consumer notification and how you complied with law. They are also going to be looking to make sure that the entity, to the extent that the entity is regulated or comes under the jurisdiction of these particular statutes, how is the entity complying with the increasing number of state information security standards or federal or other agency security standards that exist? So the issue here has to do with what was your organization doing before the incident, at the time of the incident? were they in compliance with these requirements that exist in statute? And again, many of our clients that we work with never heard of these because they haven't had proactive compliance work on the front end that allows them to identify the particular laws that they might be subject to, and then what they need to do in terms of their own internal cybersecurity program to comply. And so the risk for clients, again, once they've put themselves on the regulatory radar, as I like to call it, is now they're not only being examined as to the incident and how they responded, but whether or not they were complying with any relevant state information security standard or the federal corollary to that, particularly in the we see this a lot in the HIPAA context. This is just a highlight of some of the states that have state information security standards. There are more, but just bring that to your attention so that there's just an awareness that these standards are out there, and it's part of the questions we are asking clients about compliance once we get to a regulatory investigation is really then we have to go back and start understanding where have they been on a compliance standpoint for this. And we'll talk about some examples of one of the bigger ones in just a second, if we go to the next slide. Okay, it's a lot of language on this slide. This violates all my rules of good PowerPoint, but I wanted to put it on here just so folks would get a chance to see, the New York standard. And New York, I will say, is one of the states through the Attorney General's office that is very, very aggressive in making sure that entities are complying with this rule. And to the extent that there is an enforcement action from the New York Attorney General's office, a major component of that enforcement action will be what was your security posture before the incident as it pertains to compliance with this? And how are they essentially going to force you in the context of a settlement, which is usually the way these go, to comply moving forward, and what that compliance is going to look like. So you can see here that this particular law applies to any person or business that owns or licensed data that includes private information of a resident of New York. And I think this is where this tricks up a lot of our clients is you don't have to be, as a business, physically located in New York. You have to hold the data of a New York resident, which is going to apply to many, many, many of our folks. I will say that I do not find that the New York Attorney General's office reaches out of state for purposes of strong enforcement on this. But in circumstances where my client is based in New York and there was a significant impact to New York residents, I'm going to say 75,000 or more, then they have a heightened interest in making sure there's compliance, and they're going to be more likely to follow up on this. But again, it's important just to note for that this applies to a lot of our client base. And again, New York's not going to reach out so much to ensure compliance, but it would really, to the extent that you've got a New York-based entity who holds New York-based data, the likelihood that they're going to have an enforcement action on the back end of a serious incident is going to go up. As you can see, in terms of compliance, actually, we'll go back, Kim, just to that one. I just want to note at the bottom, it essentially says they're telling you in statute what a business needs to do in order to be compliant. There are not hard answers to all of these. They just require to assess the sufficiency of safeguards in place, have a process for it, regularly test and monitor, right? So they're not being very specific about how these things need to happen, but it's all going to be judged on a reasonableness standard at the end of the day. And now we can go to the next slide, Kim. For many of our clients who are in the small and medium sized business landscape, some of these hard rules will not apply to them. Many of the states have standards that are different, essentially, for larger sized organizations. And again, even the NYDFS rules are a little bit different for, depending on the size of the organization. Smaller organizations can be exempted from some, but not all of the requirements. And you can see here that the New York business law does in fact have an exemption. However, even though it has an exemption from some of the very specific guidelines, they will still say, and other states are sort of following suit in this, that that there has to be some security program in place, and that security program has to have reasonable administrative, technical, and physical safeguards appropriate for the size and complexity of the small business, the nature and scope of the small business activities, and the sensitivity of the personal information that the entity holds. So if you are a small organization that may not be subject to a number of these heightened requirements, but if the very nature of your business is holding large amounts of PI, and that's part of your business model, then they're going to look more seriously at the controls that you have in place, because their goal at the end of the day is the protection of New York residents' PI that is sitting right in these businesses' network. Critical to this, failure to comply can have pretty serious consequences for, as I said, typically a New York business that has an incident. They deem these violations to essentially be violations of the Deceptive Acts and Practices, so Unlawful Trade Practices Act for purposes of the state of New York. You'll see very common bases for actions across other states who have a similar statute, and that the Attorney General can bring an action in order to do this. We've dealt with the New York Attorney General's office on this on a very variety of fronts, and that civil penalties are available to them. And I think one of the things that's important to note is New York has some specific regulations that are unique to New York that indicate that these fines, these civil penalties under these actions cannot be paid for from insurance. So these can have a pretty substantial impact on our clients. And again, it's one of the key factors that we're talking about clients and the carriers about once we get to this stage of the matter. So next slide. All right, again, so how is this relevant to sort of both our clients and to carriers in our landscapes moving forward? Again, your risk of final penalties is not just about the consumer notification and the incident. It's going to be about your early proactive sort of compliance program. And so getting folks to take a look at that is important. And even, we talk to carriers about underwriting considerations. We know a lot of the carriers are looking at, attestations from insureds, potential insureds related to, let's say, whether they've got MFA in place or other network security incidents. But we expect that we're going to see more questions about this kind of compliance as well, since it's going to play into whether or not we're going to have fines on the back end from a regulator. And again, having that proactive data privacy compliance program in place is really key for us on the incident response landscape to making sure we've got the tools to help the client through a regulatory investigation. So next slide. All right, let's talk a little bit about what regulatory inquiries actually look like and how they play out. Typically, after Kim walked you through how it is we do the regulatory report in the first place, letter or portal or something else coming from Constangy on behalf of the client. Typically, that regulator who's got a follow-up question is just going to email the attorneys that sent the initial reporting out, and we can vary substantially. And so in all of our regulatory reportings, if we send a letter to North Carolina, it says we had an incident. The North Carolina, very lovely woman by the name of Megan in the North Carolina AG's office will send you an email that says, was this a ransomware or business email compromise incident? And you respond and say it's a ransomware. And oftentimes that's the end of the line for North Carolina. However, a lot of the other offices are sending us very detailed requests for information. Again, sometimes it's just going to be subject to an email. Florida has done that a lot. And sometimes you're going to get a very substantial, akin to an investigative demand, with anywhere from 1 to 30 or more questions and requests for production. So not just narrative questions, but they're going to start asking for things like compliance-related policies and other programs that people have in place. The request for responses can sometimes be very quick. We try and push these out as far as we can to give ourselves and the client time to prepare. Most of the regulators will give you extensions I'm going to say that not all of them will. And just yesterday, I was on a call with a client in NYDFS. And NYDFS, when you file with them, follows up on almost every single one. They will request not a written response, but typically an interview, an on-camera interview with their team, counsel, and a point person at the impacted. They want to hear from the client, so we've got to do a lot of prep to get folks ready for that, and they typically won't allow you to delay it. So you have to really understand what the goals of the particular regulator are. We'll talk about that in a minute, and really just what to expect generally based on that regulator's prior experience. And as I said, they will ask for sometimes the sun and the moon in these responses. So not just information about the incident and your response, what happened in the investigation, consumer notice, your security posture at the time. They can be very detailed. Next slide. Okay. Oftentimes, excuse me, oftentimes the questions might need some clarification. Again, most of these regulators are fine jumping on a quick call to clarify those if we need those, or clarifying those in writing. Again, I'm often getting the extensions that we are seeking. We oftentimes will request to do a verbal identification or response as opposed to a written, and maybe start with the verbal. And one of the reasons we're doing that at that particular time is to limit the information about the incident and the response that is written, that then would be subject to discovery in what is often a simultaneous class action lawsuit. So we are often coordinating with class action defense counsel about the status of that matter, what their thoughts are in terms of how they think additional disclosures to state agencies work, because not only then is it subject to disclosure, but you're also in a situation where it may be subject to public records requests in that particular state. Utah has done a really interesting thing now that when they send out the request, they also send out a confidentiality agreement to sign separately, which is great for our clients that they've recognized that they're going to take additional steps as much as they can to protect these kinds of responses from public records requests, because that's certainly a concern for our clients, that information about their incident and the response to it could end up being part of the public record, which no one wants to have in conjunction with one of these. So we've done the responses. We've got the initial response. How do we know if it's going to escalate? Again, the large portion of these are really just responding. And the goal really for us with most of these regulators is to help them do their jobs, right? I had a conversation with the regulator the other day, and we were joking about the fact that, the worst thing in their mind that an insured and their counsel can do is not respond or be evasive, because that really brings their laser focus in terms of where they're going. But if you can give them the information they need, oftentimes they've just got a checklist that they've got to get through as a regulator. They've got some direction perhaps from either their attorney general or their legislature about collecting information. Sometimes these are just intelligence gathering exercises on their part, and really not about an enforcement action at the client. So again, just trying to test the temperature of that and understand. But if we receive a series of inquiries, and again, NYDFS is always going to ask for that interview on the front end, but some of the other AG's offices, if we've escalated to the point that they want an interview with the client, then I warn clients, we are likely looking at a regulatory enforcement action that will likely involve not just steps to bring that entity into compliance with the security standards, but a fine. That's normally what the big concern is. So next slide. Okay, we've got another polling question. So over to our polling question, folks. How is a regulatory investigation initiated? Search warrant, email or letter, phone call, or they aren't initiated? So we'll leave it to the group to answer here, and we'll be back to that in a minute. Okay. Oh, question 2. There we go. Do we have our answers? All right, email or letter. Yay. Excellent. Great work. And it could be a search warrant, but luckily it's not for most of our cases. So that's it's good to know. That would be a very aggressive response for sure. So let's move into talking about regulatory enforcement actions with the last 10 minutes that we've got here for our presentation, which is a few more slides left. And again, if you've got questions at any point, please let us know. As I said before, I mean, really, and our approach has been the best practice once you're in the landscape of the enforcement action is coming. Keeping an open line of communication with the assigned assistant attorney general at the state or whichever entity you're dealing with, the primary assigned investigators and attorneys that are with that. It's just helpful, again, to keep that line of communication open, to understand, where they're going, and to really work with them and to convince them that your client is concerned about compliance and is going to do what they can to bring themselves into a landscape where the compliance, sometimes this is just confusion about, what security standards and practices your client has in place and how they really play out relative to their own network. And so just making sure that things are as clear as possible on behalf of your client. And this is really where advocacy is coming in. This is the point in time where we are trying to convince a regulator that our client is close to or trying to be in compliance, and also oftentimes to attempt to mitigate any monetary fine in any way we can. So typically the office will send over a proposed settlement. I've seen proposed settlements come over after lengthy discussions and a lengthy investigation with some basis for it. I've seen regulators just send one, like, we're going to do a regulatory action. Here you go. The draft of usually it's called an AOD or assurance of discontinuance, something along those lines, essentially has proposed findings of fact about the incident and the security posture of the entity, allegations about the violations of law, which we always make sure in the final version say that the respondent neither admits nor denies. These are going to end up being public filings, often filed with courts. It will also state the relief that's requested, right? And oftentimes this is improvements to the security posture of the particular client that would bring the entity into compliance with that particular agency's standards. And then, of course, fines. We do oftentimes see fines associated with these proposals. Next slide. All right, and once we get these, this is where we start having conversations with carrier, with the client. What are the pros and cons of settling? And oftentimes it is in the client's best interest to try and come up with a lower value settlement. Many of our clients are often moving in the landscape of compliance with security standards post-incident, regardless. And so sometimes that's a lesser lift. Certainly, many of our clients, discuss the fact that they may not have the budgets to put in place the security enhancements necessary. And that is obviously a part of the conversation we're having both with the client and with the regulatory authority about what's possible in the landscape of budgets. If you don't settle with a regulator, which is always an option, then there are the risks. The risks that the office is actually going to bring a lawsuit. That's, if you don't settle, that's their option. They can bring a lawsuit after that, and then the risks related to litigation. We don't see it that much. It does happen, but the risk is always there. And in the context of litigation, you would have discovery about the incident. And again, oftentimes what the client is trying to avoid is open discovery about what happened in the context of the incident itself. And of course, fines certainly could be higher. Our goal always is to negotiate the lowest fine possible, perhaps to have that fine, imposed over time or even suspended if certain actions are taken on behalf of the client. So at this point, we're working with the client to revise the proposed AOD and return it. Make sure the facts that are included are as narrow as possible. Again, most of these offices are looking to do a press release at the end of the day where they're going to post this and do a story on it. And so we want to keep it as narrow and as straightforward as possible, kind of bring down any language that was in there that might be inflammatory. As we said, any remedial measures really need to be possible. And in terms of fine negotiations, I will work with the client to really get a high-level overview of every fine, publicly known fine in this landscape that's been imposed in the last 5 years. What was the size of the organization? What was the, what were the underlying facts? How risky were they? And really try and bring our fine down in terms of our, measuring stick, in terms of how big is our organization, what are our annual revenues, how many people were impacted. I do see that there is a question from Elliot. So the question is, how negotiable is written notifications in the regulator's eyes, especially if it's a large number of individuals? Has their opinion on this changed in recent times? I mean, every state regulator we're looking at wants to see us doing written notifications in the first instance, right? And even in the HIPAA landscape, there's just no way around that. I would say that regulators disfavor substitute notice. So to the extent that we can do written notifications, they are looking for that, and it is something that they want to see. Justifying substitute notifications in multiple states can be very, very difficult based on the analysis we put in place. We're often doing it in the HIPAA context because we have so many missing addresses, but they are going to want to see an effort to do written notifications in the first place. So hopefully that answered your question. We're going to move on to the last slide. We've got about 3 more minutes here. Just as we're doing these kinds of strategies and negotiations, you really just have to keep in mind, where is this regulator coming from? What is the primary goal of the particular office head? State AGs are elected. Sometimes they're running on a platform of things that are priorities for them. The New York AG has this as a priority. They are going to do a lot of enforcement on this landscape. The last Oregon AG had this as a priority of hers. We haven't decided or seen yet whether the new AG this last year is going to do that as well. So it's important to understand that. AG's offices, other offices also, there's financial motivation there. Fines that they impose often go into accounts that they can utilize for, we used to call it the slush fund. There's sort of more slush fund. It's unrestricted dollars that they can utilize for their own actions. And certainly they're looking to do press releases, to use these kind of enforcement actions as a deterrent and to reduce the risk of non-compliance, saying, hey, look, we really are going to come after you if we're doing this. And again, as I said, when you're proposing counter offers, and sometimes we go back and forth, we have counter offers back and forth 3-4 times before we come up with a final version. You're really going to be making the argument about, how do we line up with other similarly situated size entities with similarly situated conduct, because they're going to want the bar to be even across the publicly known board. So that's going to be a big issue for them. Next one. And Kim, why don't we skip down to the question, because we're about to run out of time. There's additional, if you have the slides in here, just before we get to this one, actually, we'll go to the summary one right before. Oh, we got the question. We'll stay with the question. So last question, what are different reasons that regulators pursue administrative actions? Funding, deterrence, consistency, or all of the above? And I'm hopeful after this presentation that we're going to have a really high rate of return on this one. The previous slides talked a little bit about the fact that in addition to our incident response services, we do have services where we can assist clients and carriers as they're assessing, what is the landscape of proactive compliance that they need to be aware of. So please keep in mind that our proactive compliance side can work with, your entities, your clients on making sure that they raise up. And then obviously on that last polling question, the answer was all of the above. 100% of folks got that answer. So we really appreciate you joining us today for this. I know we're at the top of the hour. If you've got any questions for Kim and I offline after this, certainly you can just pull up our email addresses from the Constangy website, and we'd be happy to connect with you after this. So thanks everyone for attending, and we really hope this was helpful.